Okay, good afternoon, ladies and gentlemen. My name is Ronaldo Hilton, the Chairperson Designee of the New York City Loft Board. Welcome to our July 18, 2019 public meeting. Section 282 of the New York State Multi-Dwelling Law establishing the New York City Loft Board. The board is charged with overseeing the conversion of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences which comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. At this time, before we begin our formal meeting, we are going to have a motion to go to executive session to discuss litigation. Mr. Delaney, is there a second? Mr. Schachter. We're going to, ladies and gentlemen, we're just, I'm sorry, all in favor? Is there there's no discussion. Is there any vote on this matter? Could you please poll the board members?
Mr. Parker? Mr. Rose?
Yes.
Mr. Delaney?
Yes.
Mr. Schachter?
Yes.
Ms. Torres?
Yes.
Ms. Roseman?
Yes.
The Chairperson Hudson?
Yes.
6 in favor and 3 absent.
Thank you. At this point, ladies and gentlemen, you can just stay where you are. The board will just go in the back to discuss a private matter. That we go back to public session. Is there a motion? Mr. Schachter, is there a second? Mr. Roche. Mr. Rivera.
Mr. Parker?
The motion is to go back into public session from executive session.
Yes.
Mr. Rose?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schachter?
Yes.
Ms. Torres?
Yes.
Ms. Roseman?
Yes.
Chairperson Hudson?
Yes.
8 in favor, 1 absent.
Thank you, Mr. For the members of the public, we just had gone into executive session to discuss a litigation matter. Thank you. So we will continue now. The next thing on the agenda is a vote on the June 20th, 2019 minutes. At the board's request, staff added conclusions for the master case to these minutes. Are there any corrections or comments on these minutes? Mr. Delaney.
Yes, a question on page 4.
Can I ask you to keep your voice up?
Sure.
Thank you.
Question on page 4 with Mr. Chairperson Hilton. They asked Ms. Paulson if she could try to find out the situation would be if special interest positions weren't all filled. And I was just curious. It's about 3/4 of the way down the page, on page 4. And I was just curious if you've had a chance to do that.
I did actually ask. I don't remember the answer, so.
That's fair.
But I did actually ask, but I don't recall what the answer was, but I can forward that.
And on page 13, 2/3 of the way down the page, in the paragraph that begins with Ms. Paulson saying, I don't even care if they're renting it out for profit. Third line down, it says, I don't approve of rent gauging. I think that's gouging. Yeah.
That's on what page?
13.
Yeah. Okay. Thank you.
I don't know, there might be another one.
No?
We have to find out how to spell gouge.
Okay. G-O-U-G-E,
Gouge.
Oh, G-O-U-G.
Thank you. Ooh, it's good.
Other than that, another superset of minutes.
Okay.
Is there a motion then to accept the minutes with those corrections, with that correction? Motion. Is there a motion?
Yes.
Mr. Delaney, Mr. Rouge, just second. Ms. Rivera.
Mr. Bond. Ms. Flowers.
Abstain.
Mr. Booth.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shatner.
Abstain.
Ms. Torres.
Yes.
Ms. Rosen.
Yes.
Chairperson Hudson.
Yes.
6 in favor, 2 abstain, and 1 abstain.
Thank you, Ms. Rivera. Ms. Balsam will now present her Executive Director's report.
So, particularly in light of the new law, we're continuing to try and update the forms on the Loft Board's website. We're working with the city's Department of Information Technology and Telecommunications to get the forms uploaded. We've had some snags, but we do have, if you want to see what they look like, I brought them. So registration applications under 281.5 and one under 281.6. And we also have coverage application and general applications. So if anybody wants to look at them, once they're posted, we would appreciate it if you use them. Eventually, they will all be fill-inable PDFs. So that is in the works. We do have some extra copies if anybody wants to take them with them. In terms of revenue, our unofficial revenue for June was $173,930. That's because of the registrations. So the money keeps pouring in for the registrations, which is good. In litigation, we have one discontinuance and several new cases. The discontinuance is the case of Steinbauer et al. Versus Loft Board. These are tenants who filed an Article 78 petition asking the court to annul, vacate, and reverse a Loft Board order which denied protected occupancy status to the petitioners who are the roommates of the prime lessees. At the request of the petitioners, the case was discontinued with prejudice. The petitioners reserved their right to refile for protected occupancy status if the circumstances in the apartments change, which I take to mean that the prime lessees leave. We have two cases from 99 Sutton. In the first, the owner is challenging the Loft Board's affirmance of the staff determination, which rejected 32 purported sales of rights. The second case, the owner brought a mandamus proceeding seeking to compel the Loft Board to decide whether additional sales of rights for the same units filed with the Loft Board earlier this year are valid. In 199 Dashing versus New York City Loft Board, that's a mandamus proceeding seeking to compel the Loft Board to decide a coverage application. In 470 Manhattan Avenue LLC versus the Loft Board, the owner filed a coverage application with the Loft Board, claiming the building could not be legalized due to its construction classification. The building was in the middle of the narrative statement process when the application was filed. Loft Board staff issued an administrative determination holding the coverage application in abeyance and allowing the tenants to file an alternate plan. Owner wants the Loft Board to decide the coverage application. In Ellen Robinson versus New York City Loft Board, this is a case where the tenants are actually challenging coverage under the loft law. They claim that the building is covered under the Emergency Tenant Protection Act, and the board had actually ruled that the building is covered under the loft law. And finally, Michael Joseph Malik versus New York City Loft Board and DOB is a mandamus proceeding seeking to compel the Loft Board to decide a removal application, which we are working on. And that's it.
Thank you, Ms. Balsam.
I'm sorry, can you just go, how many separate,
Mandamuses?
well, how many, the first was
1, 2,
Steinbauer
3, 4, 5,
discontinued.
6, 7. Right, so Steinbauer was discontinued, and we have 1, 2, 3, 4, 5, 6 new cases.
Okay. Would you be so kind as to send me the papers?
For all the new cases?
Yeah.
Sure.
Are there any additional questions for Ms. Balsam?
Trying to think of how to rephrase this. 470 Manhattan Avenue, is that known by any other address?
18 to 20 Edford Street.
I see. Thank you.
If there are no other questions, Ms. Boston, then we turn now to a vote on the cases. The first is the appeals and reconsideration calendar. There are two cases on the appeals and reconsideration calendar. The first case is Amicus Associates Limited Partnership, 83 Canal Street in Manhattan. The docket number is R0368. Mr. Conn will present this case. One second. Mr. Conn, go ahead, sorry.
Good afternoon, everyone. Before the board today is a proposed order for a reconsideration of order number 4811 issued in October 2018. The underlying case involved a group of tenants of 9 units at 83 Canal Street who filed a joint application for Article 7C coverage of their units and protected occupancy status. The parties entered into settlements under 9 stipulations. Settlement between the owner and Mr. Seife, the occupant of one of the units, provided that Mr. Seife's unit is subject to Article 7C coverage, that Mr. Seife agreed to sell his Article 7C rights to the owner, and that the owner would record the sale with the Loft Board. The other 8 stipulations all contain terms providing that the owner would register the other tenants' units and recognize the other tenants as protected occupants. In return, the tenants agreed not to withhold their rent based on non-compliance until the Loft Board issued a decision on the owner's application for extension of code compliance deadlines. In January of 2017, the owner filed an extension application, which the executive director granted through January of 2018. Immediately prior to the deadline expiration, the owner filed for a second extension, which the executive director denied. Shortly thereafter, the tenants stopped paying rent. On October 18th, 2018, the Loft Board issued order number 4811, which, among other things, directed the owner to register Mr. Seife's unit as an IMD and list him as a protected occupant. The owner subsequently registered the unit but did not identify Mr. Seife as the protected occupant. So owner now seeks reconsideration of order 4811 on 3 grounds. The owner alleges material fraud by the tenants because they allegedly breached their stipulations by withholding their rent. In its allegation, the owner contends that the tenants breached the stipulations. However, a breach of stipulation without some proof of an intention to deceive is insufficient to support a finding of misrepresentation or fraud by the tenants. The owner also alleges a denial of due process in the prior proceedings and an error of law by the Loft Board because it stated in the order that the unit remained rent regulated until it filed a sale of rights form. However, there was not a denial of due process because there was no hearing in this case and thus no prior proceeding. There's also no error of law because the owner misinterpreted the language of the order. The owner still must file an acceptable sales record and sales agreement if the owner wishes to have the Loft Board's record reflect the sale of rights. Owner fails to state a proper ground for which reconsideration may be granted, and consequently the proposed order denies the owner's reconsideration application.
Thank you, Mr. Cohen. Are there any questions? Excuse me, is there a motion to accept the case? Mr. Delaney, and the second, Ms. President. Are there any questions? Comments? Ms. Rivera, would you please poll the board members?
Mr. Roberts?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Davis?
Yes.
Mr. Shaka?
Yes.
Ms. Torres? Yes. Ms. Grossman?
Yes.
Mr. Kozowitz?
Yeah.
8 in favor, 1 absent.
Thank you, Mr. Rivera. The next case is on the appeal and reconsideration calendar is 40 Dover LLC. The address is 34 through 40 Dover Street in Manhattan, and the docket number is R0371. Mr. Chichora will present this case.
Good afternoon, members of the Loft Board, members of the public. In Loft Board Order 4831, the board issued a $10,000 fine against 40 Dover LLC, the corporate owner of the building at 40 Dover Street, due to the building's delinquent registration status for 2 consecutive fiscal years. On December 7th, 2018, owner filed for reconsideration of the order. Owner claimed that it was denied due process because its agent was out of town and unable to present at the board meeting when the board issued the order, and that its agent left a voicemail with the Loft board that was never returned. Pursuant to 29 RCNY Section 103E, owner would not have been able to participate in the board's public meeting, even if its representative was present. Moreover, even if it were true, a single unreturned voicemail is not a denial of due process. Owner has failed to show it is entitled to reconsideration. For this reason, the proposed order denies owner's reconsideration. Yet as of this morning, there was a change to the proposed order, changing the conclusion because the Loft board tendered a check for $13,000.
The owner.
Yeah, yes, the owner, a representative of the owner came and tendered a check to the Loft board.
So is there a motion for us to accept this case?
So what?
Before, we're going to go into questions.
Yes.
Mr. Delaney, is there a second? Mr. Bowers. Okay, so are there any questions or comments? I'm sorry. When I say questions, I mean comments. Any comments? I think you had a comment.
Well, it was not made clear what the new proposed order is.
Right. Could you just say what we decided?
Sure, so if you look at the proposed order, and there's in the conclusion section, it says this application is denied, and then there's 3 paragraphs outlining the owner's current status with the Loft board, and so we've stricken all of that, and we just wrote that on today's date, the Loft board received a check from owner's agent for $13,000.
13,000,
That's right.
13,500.
13,500.
Apart from that, the order remains the same for us.
That's right.
Do we have any more questions, comments on this?
The order is amended?
It will be amended, the final,
Okay.
with the last 2 or 3 paragraphs stricken,
That's right.
and after the word, after the words,
So everything in the conclusion,
our owner's application is denied. After that, we
Everything
would just say that,
that on today's date, the Loft board received a check for $13,500 from an agent of the owner,
thank you,
and that's it.
thank you. Any other comments? Is there, Ms. Rivera, could you please pull the board?
Mr. Barrett?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mrs. Delaney?
Yes.
Mr. Shacker?
Yes.
Ms. Torres? Yes. Ms. Roseman?
Yes.
Chairperson Hudson?
Yes.
8 in favor, 1 absent.
Thank you, thank you, Mr. Petro. There are 3 cases on the summer calendar. They're voted on as a group. The cases are Catherine Hartland and Jaren Miller at 151 Kent Avenue in Brooklyn. That docket number is PO0084. Second case is Ricardo Fernandez, 255 McGibbon Street in Brooklyn. Docket number PO0085. Then there are various tenants of 13-19 North Oxford Street. The address is 13 through 19 North Oxford Street in Brooklyn, and the docket number is TR1207. Is there a motion to accept these cases? Sorry, Mr. Hernandez, is there a second? Mr. Rush? Do we have any comments on these cases? No.
Yes. No.
Yes.
Well, so the 2 are,
The 2 mean the first 2?
the first 2
Yes.
are carried forward from last month because we voted.
Speak loud.
The first 2 carried over from last month as they were not voted, the vote was not an approval.
We didn't have a
No.
Five,
Right.
yes.
Right. And nothing has changed since last month, right? Still the same order, still
Right.
the same case. But now we're grouping together with this third one. So I know there was a little discussion, further discussion on these, but I think I would say that the concerns raised last month are still valid and open concerns.
True. If they're still your concerns, but we still don't have any sort of,
You're asking to vote
separately, is that,
on the three different,
I mean, the question is, are you asking to vote on it separately so you can, so you're able to vote?
I would recommend that we separate the first two from the third, please.
Sure. So I can do that.
I have a general question.
Yes, sir.
Did I not read in the new rules that we're going to get more information about these stipulation agreements?
In new rules?
So
Or did I misread that?
the new rules haven't passed yet, but I think what you're referring to is the sale of rights.
Yes, yeah.
Yeah, but these are not
And
necessarily
since
sales of rights,
these
these
are not
are just
under the new
stipulations.
rules, it doesn't carry.
Right.
Okay.
So, to address Ms. Roseland's request, we're going to change we're going to split these cases into two different votes. So let me just read on the record what we're voting on now. We're voting on case 3 and 4, which is Catherine Hartland and Jaron Miller at 151 Kent Avenue, Brooklyn, docket number PO0084, and Ricardo Fernandez at 255 McGibbon Street in Brooklyn, docket number PO0085. Do I have a motion to accept these two cases? Mr. Schachter, is there a second? Mr. Bowers? Mr. Rivera, do we have any comments on these two cases?
Same comments.
Same. Ms. Rivera, could you please poll the board members?
Mr. Barros.
Yes.
Mr. Roach.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
No.
Mr. Schachter.
Yes.
Ms. Torres.
No.
Ms. Roseland.
No.
Chairperson Hudson.
Yes.
5 in favor, 3 against, 1 absent.
Thank you. That motion is passed. The next case is various tenants of 13 through 19 North Oxford Street. And the address is 13 through 19 North Oxford Street in Brooklyn, TR 1207. Is there a motion to accept this case? Mr. Hernandez, is there a second? Thank you, Mr. Roach. Are there any questions on this case? Comments on these cases? This case? Single? No comment? Ms. Rivera, could you please poll the
Mr.
board?
Barron.
No.
Mr. Roach.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
No.
Mr. Schachter.
Yes.
Ms. Torres.
No.
Ms. Roseland.
Yes.
Chairperson Hudson.
Yes.
5 in favor, 3 against, 1 absent.
Thank you. There are 3 cases on our master calendar. They are removal cases and are voted on as a group. These cases are HH West 20th LLC and 196 Nevins LLC. The address is 17 West 20th Street in Manhattan, docket number LE 0709. Then MKF Realty Corporation, 35 West 19th Street, Manhattan, docket number LE 0710 and RG 0204. Finally, 177 West 26th Street, 177 West 26th Realty LLC, and that address is 169 through 177 West 26th Street, and that docket number is LE 0711. Do I have a motion to accept this case? These cases, Mr. Roche. Second? Oh, I'm sorry, Mr. Schacht. Tend to look to two different sides. Do I have any comments on these cases?
I was just going to comment, I think I did this last time, but I just, for the sake of the public, it's a little obscure, I think when a building's leaving the loft board, it's interesting to keep a tally of, is a building being decovered and how many units end up being covered as IMDs versus sale or rights, no one protected left.
And how many revert to the manufacturer?
Right, how many revert to?
Want Ms. Balsam to say something on
Yes.
that?
Thank you.
So the 3 buildings involve 30 units altogether. 10 of those units are reverting to commercial, or have already reverted to commercial. 18 of them are market rate units, where the tenants were bought out, and 2 of them are rent regulated.
Thank you.
All right, is there, any more comments on these cases? Mr. Herrera, could you please poll the board members?
Mr. Barrett?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Levy?
Yes.
Mr. Schachter?
Yes.
Ms. Torres?
Yes.
Ms. Grossman?
Yes.
Chairperson Hilton?
Yes.
8 in favor, 1 absent.
Thank you.
Mr. Chairman, before we go on to discussion of rules, I just realized that at the end of the executive director's report, you very quickly noted the coverage, the new application forms.
Yes.
And I would just like to ask that we set aside time at one of the meetings in September, I believe we have 2 meetings scheduled for September, to review the forms as a group.
Are you going to provide forms?
Well, I mean, the forms are there.
You want us to
I gave everybody. I'm not opposed to that, it's just that we have a lot of work to do in terms of rulemaking, so I'm not sure.
Are you saying the board should review it, or you want to make comments on it?
Well, having just seen them now, I'm not in a position to make comments now.
Right.
I repeat my observation that I've made several times, that back in 2014 or 15, or whenever it was, that protected occupant and coverage applications were split apart. That was done by staff with no consultation with the board, no public hearing, no discussion. And as Executive Director Balsam frequently reminds us, staff only does what the board wants it to do. So it would seem to me that at least spending 15, 20 minutes looking at the forms would be part of the board's obligation.
Right.
So therefore, I'm asking that it be put on the agenda.
Can I just refer what you're asking and tell me if this is okay with you?
Sure.
Is that we provide the forms to the board, which I think you should do that now, and the time that you're asking for is that so much?
There you go.
Okay.
Just trying to bring up the rules.
The time.
When we all read this, and then if we have a question, we can ask the question.
Well, that's what I was just. That's what I was going to say. So the time that we'll set aside the time for that you're asking for any feedback on the forms, right? Because I don't want to. I don't want anyone if there any feedback. So I don't want to set the time for people just to start looking at the forms. So you can look at it now, get comments or feedback, and then we'll discuss those feedback.
Yes, I would just ask that it be,
Sure.
be in the
So that would be on September,
The agenda.
the first meeting in September. September.
Can we find out whether or not anybody has anything to
Well, they
discuss
have-
before
they
we
have-
put it on the
Well, they may
agenda?
not have looked at it yet.
No, I understand that, but why don't they look at it, and then they can say, I have nothing to say, or I have things to say, and if we need to put it on the agenda, we can put it on the agenda then. We don't have to put it on the agenda now.
So we have
So
to
say-
email you
Yeah.
2 weeks in advance.
Yeah, take a look and
Yeah.
see if you have any questions or comments. I mean, they're fairly straightforward. I don't
Well, it seems to me, if we put it on the agenda, then the public's on notice. Number two, if it ends up being a 2-minute discussion.
That's fine.
It's never too late.
No, that's fine, that's fine. It's going to be, we'll put it on the agenda for September 5th. All right. Any, so now,
Before we go to rules, if I have a question, well, I'm wondering if there's an update about project guidelines from DOB.
well, I think we're still within that 2-week period that the senior staff, especially the commissioner's office, asked for to review.
I don't think the board knows the whole.
We talked about it, didn't we talk about it last week?
We didn't mention?
I don't remember.
Okay, so, I thought we did.
Okay,
Oh, I know.
okay.
So the project guidelines are essentially finished and completed. However, with a change in executive leadership here at the Department of Buildings, that the Commissioner's Office has asked for a 2-week review period. That's 1 week has passed since then. So, okay, they want to review and make sure that what they're putting their nod to is what is good, is okay with them. So we expect that by next week we'll have some clarity from them where how they want to go forward with this, but it's completed. At least the draft, the way it was. Thank you. Sorry about that, I thought we had mentioned that before. So are there any other comments before we go into rules? We will now continue our discussion on the proposed rules. Ms. Boston will lead the discussion.
So in terms of 208, which we had discussed last time, the board had given us a list of things to look up and some homework to do. So I've given you a couple of documents. One is some notes. One is part of the New York State codes and rules and regulations, and the other is actually a table from a law which was repealed. So it's a lot of material, so I wanted to get that to you. I just finished it this morning. So I figured that next time we could talk about this material, but I wanted you to have it, and it answers all of the questions that were raised. I think it answers all of the questions that you raised at the last meeting.
There are 4 documents.
There should be, I think, 3.
Oh, I'm sorry, I'm counting.
There's one that says notes on proposed rule changes based on June 20th, 2019 meeting, right? And there's one that says New York Codes, Rules and Regulations.
There's one that says which that.
Huh?
There's one that says which that.
Yeah, that's actually, if you look at the bottom where it says Table 1 Environmental Rating Criteria, rating, and that's all, it starts actually on the next page,
Okay.
okay?
Did you send it digitally?
I did not, because I just finished it.
Okay.
I can certainly send it to you digitally.
Yeah, that'd be
Yes,
great. Thank you.
yes. But start with the notes pages, because the notes refer to the other documents. Okay? So definitions of the zoning resolution, the definitions of seller, definition of JLWQ, all of the things that you asked about, I put in there.
Thank you.
You're welcome. So that brings us to Rule 201, which starts on page 37 of your books. For the members of the public, we have handouts for you. If you don't already have them. Well, actually, it starts on page 38. And let me just say, as we go through, some of the proposed changes that are here are things that the board has already discussed and voted on. So I'm going to recommend that we skip those. I don't know that we need to revisit them at this point. So, and that includes the changes, the strikeouts on page 38 and 39, which are definitions which were moved to the front. Yes.
So, as you doubtless recall, recall, we discussed in section 208, some places where we're going to have definitions in both places, but here in 201, the preference is to get rid of the definition.
Unless you want them there, I mean, I can put them back, it's no big deal.
No, I'm just,
No, I was actually thinking that, like, I don't, we made a clear decision. I
No, we're all
said
over
they were looking at the idea.
Yeah.
I prefer definitions in the definition section and sticking to that, like, really tight.
Unless there's a reason to have a different definition.
And then
that has
I
to
like
be done.
Carver mentioned capitalizing the words.
Yes.
And I think that's good, and so you always know when you pick up wherever you're at, you know that it's gonna be.
This is the,
Yeah.
right. Okay, so again, the strikeouts are old. So that brings us to the bottom of page 39. So the way that the rules were structured, there's code compliance deadlines. There's rules about code compliance deadlines for 281.1 buildings and 281.4 buildings. And then there were rules about code compliance deadlines for 285 buildings pursuant to the 2010 amendments. I don't know if we had separate ones for the 2013 amendments. But anyway, I added additional paragraphs to the rule to cover the 2015 amendments of 281.5, which should have been done in 2015 and was not, to cover the 2019 amendments to 281.5, and to cover 281.6. So there's 3 new paragraphs, 11, 12, and 13, that cover those particular sections, and this is just on the bottom of page 39 is an introductory paragraph that says this paragraph talks about this paragraph talks about this paragraph talks about this. And then the substance is further on down the line. So that's what this is on the bottom of 39. Any questions on that? Okay. So then we move ahead.
I
Yes.
do have one question and then another question. You use the term building or portions of a building.
I copied what was already there.
Right. So by a portion of a building, am I correct that what you are attempting to address is another group of units?
So units in the building, you can have units in the building that are not residential, right?
Yeah, yes.
So I think you could have a building that has only IMD units, and you could have a building that has 3 IMD units and 15 commercial spaces, right? So
Right.
the portion of the building in the second building, right, would be the 3 IMD units.
Okay, and this question comes up again a few pages down the line, because obviously we have buildings that have a number of IMD units covered under 281.1, and then perhaps a unit or 2 covered under 281.5. And we will, I'm quite confident, see buildings where some units are or will be covered under 281.5 and others will be under 281.6.
Right.
So that's where I just wondered about the choice of the term portion of a building versus something that said units.
The zoning units code is already, it's already in the language of the building code and zoning resolution. So it just, I would guess that's where it came from.
I mean, this is what it said before, so I just
Right.
copied what was there, but you could theoretically, if you're hypothetical, right, like we have a building now where some of the units are 281.1 and 4 units, and there's 1 unit that's covered under 281.5, that 281.5 unit has different code compliance deadlines, not that the owner has met any of them, but that's beside the point.
Right.
But yes, I would envision that you will have buildings where you have owners that have some units that are covered under 281.5 under earlier versions, the later version, and then some under 281.6.
Okay, I just trying to see if there's some off-the-wall argument to be made about portions of the building.
There are always off-the-wall arguments.
Oh, that's good. That's reassuring.
I think C of Os are also issued portions.
We,
Composition of buildings, be more than just units, it could be floors, it could be, you know,
So the floors would be like portions of
the common areas, utilization of all areas.
I guess a portion is not necessarily contiguous.
Oh, that's true.
Maybe that's where I'm,
Yes, I would agree with that. Portions don't have to be contiguous.
Right, it doesn't, so again, we are just, I don't know, hypothetical example of the, it would say if a building or a portion of a building is within 25 feet of a district boundary, blah, 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 blah.
Right.
So it's not, it doesn't limit the, I mean, at least the way the zoning resolution code or building code is written, it doesn't limit what you're talking about. It means any portion of the building, so it could be, the back corner, it could be the floor, but if a building or a portion of the building is below curb, like the cellar is defined as the building or the portion of the building below curb level. So,
right.
Is that a message that I need to translate?
Okay?
Yeah.
All right, so then if we skip forward 10 pages, there's nothing in between that's changing, or can't find anything at the moment. That's all the old sections. So here's the new section 11. And again, this is something that was proposed 2 years ago in terms of adding this section. So these are for code compliance deadlines for buildings subject to Article 7C pursuant to MDL 281.5 as a result of the 2015 amendments.
what page did we jump into?
We're on page 49.
Oh, I only went to 45.
Yeah. So for the purposes of the public, you're skipping ahead 10 pages because your page numbers don't match. Sorry. Okay. So these would be code compliance deadlines for 281.5 buildings as a result of the 2015 amendments. And these basically parrot the language, this parrots the language that's in the statute. On the next page, you have paragraph 12 here, which is the 281.5 buildings as a result of the 2019 amendments. And then on page 51, you have the 281.6 code compliance deadlines. The code compliance deadlines for the 281.6 units. So on 50 and 51, that's new language, the stuff that's on 49, and the top of 50 was there before. I mean, the board had not discussed it, but it was there before.
Okay. I have a question with regard to page 51, lines 8 through 11. And here, it seems that sometimes we're talking about 30 months and sometimes 36 months.
That's correct.
Why the discrepancy?
Because the legislature in 2013 changed it from 36 to 30, and now they went back to 36.
So we have to be aware whether it's, it's the 2019 or 2010 or whatever.
Correct.
So would you just say that again?
I believe it was in 2013, right? Yeah, so in 2013, the deadline, the overall deadline under the Loft law to get your final C of O had always been 36 months. It was a 36-month time frame. And for reasons, I don't know because I wasn't here then, in 2013, the legislature rolled it back.
Even if you were
from
here, you
36
might not know.
Yeah, okay, that's true. The legislature rolled the total time frame back from 36 months to 30.
For the the 2013 piece.
For the 2013.
And then we went back to
36.
Just now? Or in 15?
Hold on, let me see. No, in 2015, it's also 30 months. So just now, we went back to 36. So maybe it was 36, maybe it wasn't in 2013, maybe it was in 20. It may have been in 2015 that it went back. I have a chart in my office.
You know what?
Anyway, it doesn't.
If you let me know
Either
sometime
way,
now.
yeah. Yeah, when it was rolled back to 30, but here it is definitely 36 now.
Right, so it's the infinite wisdom of the legislature.
Yes, we had nothing to do with that.
Well, you should put a big sign up in your office.
We actually have, I don't know if it's still up because we've been taking stuff down off the website that hasn't been accurate, but we did actually have a chart up there that had all of the code compliance deadlines under the different laws, and I recently updated it to have it posted. So I will let you know when it was rolled back.
Maybe you can send us that chart when you have it.
Yes?
When you got it the way you want it.
Yeah. Oh, was it 2013? Okay, so Martha just looked it up, and it was in 2013 that it was rolled back to 30 months. But the new law is definitely 36. So do you have any questions or comments on 49?
That's an odd question. There's no way that the law department go back to the state legislature and make it all the same number?
I was wondering the same thing.
I think the legislature could with the law department.
I was just going to say. Let us presume for the moment that the law would have been more optimal if that.
What can I say? So that brings us through 52. Now, the stuff that's on 52 is the extension rule, which we had discussed extensively. The changes to the extension rule, so I don't know that we need to discuss it again, unless you want to.
Yes, I would like to.
Okay.
And a couple of things. Starting on line 22, you've got some strikeout there that didn't get
Oh, okay.
Similarly, on 53, line 9.
53, line, yes, this paragraph, yes. Okay.
Line 14 on 52, and line 18 on 53. And then I had a general question posed to me by a diligent loft tenant who actually read this stuff and perhaps did not read it earlier on when we were discussing it, which is the notion that the general concept is we're going to give people one chance to apply for an extension.
No, the general concept was that we were going to allow additional extensions. That was the big change.
Yes, but for those who have missed the deadline.
They have to apply before the deadline passes.
But we have the
If they're new owners or newly covered buildings, then they can apply for an extension. Is that what you're referring to?
No, the language starting on 52, line 23, except that the owner and responsible party may file.
Oh, yes, I'm sorry. Okay, yes, for owners, sorry, I'm mixing apples and oranges. I apologize.
Well, it's,
Yeah, so
the apple
yes.
and the orange are in the same paragraph, so it's.
Yeah, no, so yes, we were going to give people who had expired deadlines a 30-day window in which to file for an additional extension. Yes.
Right.
But we'll only grant the extension if they meet the statutory standards.
Right. And the argument that was presented to me, which I thought was worth raising, is that there are some owners who have been sufficiently bad actors that the question came up is why should we even extend this opportunity to those owners?
Because whether or not they're, quote, bad actors, which I'm going to assume means they won't meet the statutory standards, is an issue of fact that needs to be determined upon an application. So, somebody is presuming that an owner is a bad actor. I'm sure an owner might have a different view on that. Ultimately, it's for first the executive director and then the board, depending on how many numbers of extensions, to decide that. But somebody who's done nothing isn't going to get an extension.
The questions that put to me was, what about a case where the landlord fell out of compliance, applied late for extension, denied, appealed, denied, sued the law court in Article 78, which the law court vigorously defended in the state Supreme Court and won? Would such a landlord who has not lifted a finger to comply, but instead takes tenants to court incessantly, be eligible to apply for an extension during a 30-day window? If so, why would the law court contemplate that? Couldn't those landlords just bring the place up to code and be back in compliance? Or could landlords be enjoined from further lawsuits and harassment during such an extension?
I don't think we have the authority to enjoin people from bringing lawsuits. I don't know that we necessarily are going to parse all of that out and go through all of the 340 some odd buildings that we have at the moment and say, yes, you can apply and yes, you can't. I think that's administratively not workable.
What is the purpose of the 30-day window? To encourage owners that are not in compliance to submit an extension application so that it behooves them to go back to work, or?
No, it's to encourage owners that have been working all along and who are not able to get multiple extensions from getting more, to get more extensions. But because of the administrative way that it will work, there may be owners who will apply even though they're not entitled and have done nothing. That owner could theoretically apply.
So because the new law allows owners to receive multiple extensions, we're sort of this.
This has nothing to do with the new law. So the Loft Board, I think it was in 2006, there were a lot of abuses of the then extension rule.
Sure.
So the rule was changed and tightened, and it was tightened to such a degree that now the pendulum had swung the other way. So this is an attempt to put things back into the middle to give owners who are working diligently an opportunity to get extensions of their code compliance deadlines, but they still have to work diligently.
So it's a one-shot deal. Yeah.
No, it's not a one-shot deal. Well, okay, yes, this is a one-shot. This 30 days, the way that the rule works now is you have to apply for an extension prior to when your deadline passes. Right? For the most part, everybody's out of compliance now, right? All owners are out of compliance now. So this was an attempt to give them, these owners that are working diligently, a 30-day window, because they couldn't have applied before, or if they did, they were denied, because they couldn't get a second extension. So we're giving them this 30-day window, file your application, and we'll consider whether or not you should get an extension, because we're changing the rule and saying, well, hey, before you could only get one, now we're saying, well, you could get more than one if you meet the statutory standards, but what do you do with the people that are already out of compliance? Right? They can't meet that deadline because they're already out of compliance.
Okay, so now if an owner applied under this window for an extension and is granted an extension, does he then now, do they then now qualify for multiple extensions?
They can ask for more extensions, but for each ask, they're going to have to demonstrate that they have been working, right? So that the reason that they couldn't finish was beyond their control. Those are the statutory standards, right? That
Yeah.
the reason that they can't finish the work is beyond their control, and that they have made good faith efforts. So those are the standards.
Elaine,
Yes.
is there a way I can get in here? So,
Yes.
thank you. So this is all about being able to apply.
Yes.
So if they apply, then you can turn them down.
Yes.
So if they're terrible and horrible and we hate them, then you'll turn them down.
Well, only if they haven't done stuff.
Well, yeah, but that's what I mean.
I don't want to get personal.
Okay, so this is all about whether we will allow them to even apply.
Correct.
Okay, so who determines whether you agree or not?
To grant the extension,
Yeah,
so the first two would be determined by the executive director, and then it would go to the board. The third request would go to the board.
the third, and if there's a fourth or fifth?
Yeah, anything more than, anything over two, the board would be making the determination.
Okay.
Is this the passage that you also wanted because you were gonna start more enforcement? And it was gonna give everyone.
Well, we are, hopefully, we'll replace our staff, and we will start more enforcement. We have started more enforcement.
So you're gonna start finding people that are out of compliance, and this was also a way then to give that landlord is working in good faith, but is out of, off the calendar, to give them a chance, like a 30-day chance. Because ultimately we want these buildings.
Ultimately, we want the buildings to be legalized,
Yeah.
right?
So wasn't it hand in hand with enforcement component, or no?
I don't specifically recall that, but I think that that's a viable argument too, that with additional enforcement, you should be able to have additional chances to come back into compliance.
No, it's good to say.
Karen, stay.
Yeah, I mean, I think I
Right.
said
Right.
that because I think that was before Heather was.
Also, it presumably would give the board more confidence about evaluating requests, with more information, of course. I mean, then the idea is you know more about whether the owner has been doing the right thing or something.
Right.
It is.
Sorry, I lost that thread. So can we move on past this, or do we have more to say about this? Do you have more to say?
When you said, are we getting more staff? You are getting more staff.
Yeah.
I mean,
Yeah. We're filling the two vacancies, so I don't know whether or not we'll get more than that, but we are certainly filling the two
We're
vacancies.
asking.
At the moment, is our enforcement initiative kind of,
At a total standstill, unfortunately.
it's clear, okay. All right. So,
Okay, so we're going to move past that. We would get to page 58.
no, I have a question on the statutory standards.
Yes. So that's on 54,
Yeah.
okay?
So, does this apply to both? Part of the problem here, I think, is the way this is phrased, going back to the portion on the prior page, except that an owner or responsible party may. So we start out the section by saying extension of current deadlines, and then we're going to set out two different general categories, one of which is little I and the other which is double I.
Right.
But we slide in, before we start double I, that language that provides the one-time opportunity for people who are out of compliance.
So you're on page 52, and you're talking about lines 23 to 26 again?
Yeah.
23 to 25. Well, this whole section talks about people who is eligible to apply, right? That's what this section is about, B1. Who is eligible to apply. We could change the title from extensions of current deadlines to something else if you'd like.
And well, the reason is then when we discuss statutory standard, my question was, does this apply, is the statutory standard just for little I and double I, or does it also apply to the one-time opportunity?
It applies to everybody.
To the one-time opportunity.
Okay.
It applies to everybody. You can't get, the law is very clear. You must meet the statutory standards to be eligible for an extension.
Okay. So then we have language there.
Yeah, because it's in two, so it's parallel.
It's two,
It's
right.
parallel to number one.
Right. So on 54, lines 15 to 18, this is where information contained in Loft board records, where it was pointed out to me by a reader that perhaps an owner's prior documented behavior and failure should be part of the statutory standard as it applies to the one-time opportunity.
We can't add anything to the statutory standard. It's in the statute. So we would be exceeding our authority to add something extra to the standards. But the rule contemplates looking at the totality of the owner's behavior. And we had an issue about looking at Loft board records, and we wanted to clarify that in making the determination, it's fine for us to look at Loft board records, right? We can look at our own records, but I don't think we could add that as a statutory standard. Does that make sense? I think it makes sense. Does it make sense?
Isn't that what it says?
Yeah, but I think Chuck wanted to elevate the Loft board records to something that I don't think we can do, unless I misunderstood.
Yeah, so Chuck, I'm a little confused because isn't what you're saying what this says?
Well, I'm trying to clarify what information contained in the Loft board records would be pertinent to the person who says, wait a minute, my owner hasn't done a damn thing, he has no grounds, but he's going to apply for this, it's just another way to run the clock. Why should he be allowed to do that? And I don't have a good answer for that.
But the clock doesn't toll when they apply for the extension. I mean, there's no tolling of a clock. I mean, they're supposed to be in compliance. So somebody who is in compliance has an extension, and that extension is going to expire, right? Then they apply on the eve of the expiration of that extension. They apply for another one. They're not in compliance because they applied for another extension. That doesn't, unless their extension is granted. So they're not in compliance for the time that that extension is pending. That extension request is pending.
Is there a way for tenants to understand, because we may have talked about this before, but let's say a case goes for 10 years, and someone forgets, a tenant forgets in the milestone point where they're at, in 2 years.
What case goes for 10 years?
I don't know, through these milestones, right? We've got
The legalization?
legalization process, we have like 3 or 4 milestones.
Yeah. Uh-huh.
And you're saying people would wait till the eve of in that 36 months.
Right.
How does a tenant keep track of where the process is at, like officially, right? Like somehow the owner knows, and you know,
It's, I
Is
mean,
it
it's
on your
public.
website?
It's not on the website, but you can look on DOB's website to see where the job is at.
So if the alteration type 1 has been filed, that would be represented there. If a permit has been issued pursuant to that alteration type 1, that would also be reflected there. If the TCO has been issued by the department, that would also be reflected there. The only time that the tenant would not know that they would be 7B compliant and not reflected on DOB's website is if the architect files a certification that basically says, the Loft Board, I certify that this building is 7B compliant. But other than that, that's the only part
Were
where
we
they
gonna
would not.
take that out of them?
We had talked about it.
Yeah, we talked about it, but definitely if a CFO's issue, that's also reflected on DOB's website. So most, all but one, and only in that very, in that circumstance where the architect files, are the milestones reflected on DOB's website. Shows when it expires, TCO expires, when the permit expires. So it's public.
Would the tenant know, let's say a landlord applies for a extension and they're granted it, how would they tenant know?
So the tenants are affected parties on the application when the landlord, when the owner applies, and they have a right to answer, just like any other application, they would have a right to answer, and the decision gets sent to them. Moving ahead.
Did you keep the start date? I was wondering if we could just go over that quickly. When you start the milestones, it's the date of,
The date the application's filed. If we're going to grant the extension, it's the date the application's filed.
so you're getting applications now?
I think I have one on my desk that has to be decided. I don't know if there are any others that are still in the answer period, but I believe I have one in my office that I have to work on.
As soon as a tenant, a group of tenants apply.
Tenants don't apply for extensions, owners.
Oh, not extension, sorry. I mean, the whole milestone, 36 months.
What about it?
Are we going into milestones or not?
I'm not sure what the question is.
You know how there's you have certain deadlines that we're applying for extension. We have certain milestones.
Right.
Narrative statement.
Right.
The ground zero, the start is
Under which,
you get is the
Which
date you
version
get an
of the
IMD.
law?
Is the date you got an IMD number 2010, but I'm curious about 2019.
no, it's not the date you get, well, the rolling deadlines. Setting aside the rolling deadlines, which are very complicated, the start date for the latest iteration of the law is the effective date of the law. So like we had one owner come in and register, and so his deadlines are running, right? For the people that have filed coverage applications, if the owners are contesting those and they're not registering the buildings, that time is still running. Now, the extension rule allows the owner of a newly covered building to apply for an extension once the building is covered, right? And so if they were granted, if that were granted, then they would get 36 months from the date of that application. Okay?
Yeah, the time clock is starting for the 30 months.
36 months. It started June 25th. Okay. All right, anything else on extensions?
Yes.
Just in this.
Bear with me a second.
Take your time.
56, lines 5 through 10, where we state that the application must include these various things. We don't really say, and if they don't, is it grounds for dismissal? Is that dismissal with prejudice, without prejudice? What's the or what?
So if you look at 121,
Just wouldn't be grounds for consideration.
Well, but does the application linger until all the requirements are met? Or is it rejected and then they have to start over?
so if you look at 121, 1-21E, which is on page 21 of your package, it says the board will not process any application unless the application package is complete. And one of the things that's included in a complete package is all supporting documents requested in the application form, which I changed. I have a note there just to tell you that some applications want the supporting documents, other applications, they can hold off until trial to give the supporting documents, they just have to make allegations. So I changed that to say that, because it said, originally it just said all supporting documents, period, and I added the requested in the application form. So they are required to submit all the supporting documents, so we're not going to process it unless the application is complete.
So does the board then reject it and then say the next week?
I guess we would probably reach out to them and say, you're missing this.
Well,
No? For the extension? Yeah, oh yeah, well, they couldn't go past the deadline. Let's say they file it on day 15 and they don't have this statement, right? So if we called them and said, you're missing this statement, they still only have the 30 days to get it in, or whatever the deadline is, if it's a really covered unit.
Well, that's what I'm trying to get a handle on here. If I can appreciate if we're dealing, let's say in the case of a new owner, and I file for an extension, and I'm kind of new to the loft law, and I didn't get this, and it's going to take me a while. But for the people where we're going to create this 30-day window, one would think if they file, but it's not complete, there should be some, it shouldn't just sit there for a year, you know, to Heather's point, does it just sit around? How long do I have to?
You have to file a complete application package by the deadline. If they haven't done that, then the application isn't going to be processed.
The deadline.
Well, because we're talking about extensions right now. We're in the extension section, right?
Right, but
So I feel like, Chuck, I feel like we're drifting a little bit because I understand that your question could span a new application or any type of application, right? So any application.
Extension.
But the same question could be asked about any application or code, right, posed.
right.
That if the application
Well, normally you
requires,
don't have a deadline to file an application, right? There are very few deadlines for the filing of an application. There are deadlines for filing of answers and, reconsideration has a deadline, an appeal has a deadline for filing an application, but there aren't usually that many deadlines for the filing of an application. But for the ones that do, they have to file a complete package by that deadline.
Right, so
That's clear.
reconsideration is a good example. So if my application is missing something, it will be untimely if I don't perfect the application by the deadline.
Yes, we've had cases,
Right.
we've had cases that said that.
How does that play out with extensions?
It would be the same, yeah.
It would be the same.
Yeah.
Okay. And I apply as an owner for an extension under the 30-day one-time opportunity, but I don't provide some piece of material. After the 30 days, do we take action and reject it?
No, we'll deny it based on that reason.
Wasn't
If they were required to file something and it's not there, then we will deny it based on the fact that it's in the code.
Didn't we just have one of those not too long ago?
Yes.
Where the application was rejected because the payment wasn't made, or there was something wasn't made, right? So the owner filed all the paperwork, but the check came after 5 p.m. or something of the deadline.
He emailed it.
Yeah.
Right, and so we
Emailed it after
had to,
hours.
or we denied it based upon the fact that not the entire application was submitted within the deadline.
Right.
Is that the one we denied, or is that the one we rejected?
There was one that was rejected and one that was denied.
Because we took the check.
Right.
Then that was the one we denied. We reject when we can give back the check.
Right. And so my question here is, for an extension application, whether it comes in under little I, double I, or this one time.
30-day provision, yeah.
30-day provision. What's the easiest way for us to dispose of it if they're not effective?
Well, rejection would be the ideal, I think. That's certainly the least administrative hassle.
Right, so wouldn't it make sense to be clear on that here?
To say that it will be denied if it fails to be complete.
If the application is not perfected by the deadline date, it will be rejected. Just make it clear what the or else is.
Well, I mean, it references 121, and 121 has the information about all of
It
that.
says board will not process.
Right.
You know, so that means we're not going to swallow it, but I'm urging us to say we're going to spit it out, if we forgive the analogy.
If the board wants that, then that's fine.
I think that language, will not process, gives us flexibility. In that if we accept it, we docket it, and then realize later that there's something missing, we can deny it. Or if the person at the window realizes that they have not filed a complete filing, it can give it back to them. I think that language gives us the flexibility to do both things.
As soon as you docket it, that's not processing. That sounds like processing it to me.
Could be processing, but it could also be the next step. It could be that, the person, the attorney that is now reviewing this folder realizes that there isn't notice to the tenants.
Yeah, I actually like this language because
It just,
well, and it also says it must not process, so then even
It
if
could be the next step.
If it does get processed, it can still be rejected because it was erroneously processed.
All right.
Right, because I think what the concern would be, you don't want to be on guard to figure everything out.
well, the person's sitting in front of them.
Yeah, right.
Exactly.
But at the same time, we don't want a whole lot of incomplete things hanging around.
Right.
So that's my question, is when do we clear the shelves?
And that's kind of where I was going. There are other different types of applications for other things in life where if you send in all your stuff and if the application is incomplete, a week later it comes back to you in the mail and they say, you didn't have everything, like your driver's license, I don't know what it is.
Yeah.
You choose something that you apply for. And that's when you know that your application's incomplete because they send it back to you and you go, oh, you read through the list again, you figure out what you've missed and you put it in there and then you
long as you haven't missed the deadline.
Well,
Right. So can we leave it the way it is?
Yeah, I mean, Chuck, is your concern that are there people out there that don't get to hear about the law board or they don't know their status?
My interest is just being as clear as possible whenever you have language along the lines of something must be this way. I find it helpful if it's clear what the concept is. I mean, it's one thing if you want to get a driver license and you don't send everything in and they send it back, you apply again. But here I'm not looking for a thing, I'm looking for an extension of time on something that already had a deadline.
still okay.
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 Well, I don't know, that's what I'm trying to figure out.
Well, if it's docketed, you get a, you get a, yeah.
If I were to leave.
No, won't we docket the application?
We send letters to for those applications that don't have deadlines. We'll say, the coverage application, you didn't sign it.
No, I mean, we'll be assigned a docket
That,
that says,
there's a
your
problem.
application, no, we got
Oh,
your
it was
application, it's been
yes.
docketed, right?
Yes.
Don't we send that? Yes.
Yes.
Yeah. So, right, so if somebody files an application and we docket it, then we send them a notice that says your application has been docketed, here's the docket number. If you're
Right.
writing to us about that, please include that number on all your future correspondence, blah, blah,
So
blah.
like anything else that you apply for, there's a proof of, you have something. I have this piece of paper, I have this passport, I have this driver's license, I have this form, I have this whatever. This is proof of my,
Well, in this case, I have proof that I've applied.
yes.
Yes.
So, and I guess my questions are based, rightly or wrongly, on having seen so many scenarios where foot dragging on the part of the owners is monumental.
Right.
So, where there's a chance to make clear that if you don't get this done by X time, it's going to be denied, rejected, returned, you've lost your opportunity, whatever it is, I'm in favor of making that clear.
If you want us to add it, we'll add it.
Can we do that?
Huh?
Can we say that?
Sure.
Okay.
So the language will not be processed? Instead of saying denied or rejected?
I think something just, when my kid was young, you get that, well, you didn't tell me I couldn't do that. Well, yeah, I didn't tell you you couldn't do it because it's so bloody obvious that I didn't think I had to. So, oh, you didn't, I thought, I didn't realize. So just, if we can be clearer, I think it will help you folks. It might help you every now and then have less to have to do.
Okay. We'll add that.
Can you just exactly what we're,
Base.
Shouldn't you just make the same language?
Yeah. I would just bring over the same language.
it's starting after, where would you put it so I know where you
Well, I think you proposed it, if I understand correctly, at the end of, on line, page 56, line 10,
Right,
right? That's what you're proposing, right?
yes.
Yeah, so we will add to that.
They already
The
provided.
board will not process any application unless this statement is included. Failure to include the statement, yeah. Something along the lines that the board will not process an application that does not include this statement. How's that?
Fine.
Are you talking?
We're talking specifically about that statement,
The architect's
not
statement.
about the whole list.
Page 56.
Statement from estimating around should include overview or, yeah, I think it has to include.
And I don't think you have to worry about the rest of it, because the rest of it is covered by 121 anyway, okay?
This is the last sentence that says the statement should include an overview.
Yeah, so after that sentence, after the word work, which is on line 10.
Instead of should, why don't we just replace with must?
No, but Chuck's concern was that he wanted to know the ramifications. So even if you said, right, I don't want to say must in that other sentence about what's in the context of the statement. Chuck's concern was the ramifications of not including the statement. So to address that, we're going to add something that says the board will not process an application that does not include this statement, or unless it includes this statement. So anything else on 56, 57, to the top of 58? I guess it's-
Just in rule triple I there at the end. See, the second sentence, we've set up the scenario where, depending on how many times your request has been made, it may be decided by the executive director or the board. Then the second sentence says that the executive director's AD may be appealed. Then an appeal of the AD must be filed. Does that also include an appeal of if it's the law board that makes the decision?
No, the law board's decision would be subject to the reconsideration rule or an Article 78. So we
Right.
could add a sentence there that says that.
That would be helpful.
Sure.
So if we're not, if there are no more comments there, I think we're going to stop. Line 10. Yes, you do have some.
I was just trying to understand that triple I. You can never exceed the maximum. So if you give two 30-day extensions, and maybe a third.
Exactly.
30-day extensions?
Yeah, or,
I mean, they would be like 9 months, 18 months, they usually, like whatever the code compliance
big
deadlines.
extension,
Well, they're whatever the code compliance deadlines are.
the milestones.
Yeah.
But it's never to exceed.
The maximum would be the 36
36
months. Right. Except for if they've already obtained compliance with 7B, they're entitled to 2 one-year extensions to get the final CFO. And that's in the law.
Beyond the 36.
Yeah.
Can I track these? You're tracking them.
Oh, yeah, I'm going to update the document. I'm updating it as we go, and you'll have another document, but I'm not giving it to you every time. I'm giving you hundreds of pages every time.
No.
So I'm making the changes as we go along. And I think for next time, we should go back to 208 after you've had a chance to review the documentation that I just gave you, and I'll send it electronically, and then pick up here on page 58 with the narrative statement, which we had a couple open issues in, so
Oh, yeah.
we can deal with those.
I guess I meant more, sorry, I meant tracking, like when we're granting extensions, that's
Oh, yeah.
kind of thing to do where we're applying trust to the person.
Right.
And as cases come forward in the year 2 and extensions have been granted and promises broken,
Right.
we're gonna know how many extensions were granted.
Yes.
That's part of the
Yes.
tracking that we get.
Oh, yeah, it would be in the, if, let's say somebody had gotten 2 extensions and they were making a third, they were asking for a third, you would get in the proposed order that they had already been granted extensions. Much like if you read an appeal from a denial of an administrative determination, if I deny an extension, right, application, and then that person appeals that to the board, so you get the entire procedural history in the order that's in the proposed order to the board. So yes, you can get the entire procedural.
Yeah, because I want to see if these extensions help compared to someone who's completely off track or.
I think that's a good point.
Okay, if there are no more comments on these rules right now, we're going to break these rules and call it quits for the evening and the summer.
Yeah.
So this will conclude our July 18th, 2019 Loft Board meeting. So our next public meeting will be held on Thursday, September 5th, 2019 at 10:30 a.m. at 22 Reese Street, Spectre Hall. That meeting is dedicated to the rules and of course a discussion on any comments you may have on the form. So board members, please enjoy your summer, and your Labor Day, and we'll see you back on the 5th.